people preparing their wills get all cut up about like, oh, I want to name all 5 of my kids joint executors because I don't want one to feel left out. That's like the worst thing you could possibly do.
Why?
Because
can't they just share the job and it makes it easier for all of them?
Yeah, they can share it. They've got to agree on everything.
Oh.
How many kids do you have, Heather?
2.
And, well, I don't know if they're old enough yet to have disagreements, or do they agree on everything?
They probably wouldn't agree on whether or not they have disagreements.
Exactly. I have 5 kids myself. To have like a situation, like trying to pick something to watch. And they're different age groups, so that comes into play, but like, forget it.
Right.
Very hard.
Right.
So yeah, kids can't agree. It's the worst. It's way better to just name one and then an alternate, right? So if that person can't or won't, another backup. And you can have multiple backups. That's really easy. But having them do it jointly, that's like you saying, I hate you to them.
Welcome to Access to Justice. I'm your host, Heather Malarick with Merrick Law, and I'm joined today by my co-host, Evan Clarke from Kahane Law. Hi, Evan. How are you doing?
Hi, Heather. I'm doing well. It's a beautiful day. Yeah, that's about all I have to say about it right now.
Some days that's all you can say about them.
Yeah. I was thinking that every week I have this meeting. Right now it's just me and my assistant at this meeting, and we have this portion called like this segue, which is supposed to like bring you in. And you give, like, one of the things that you do is you give personal and business highlights over the last week, and I've been having a real hard time. Like work is going fine, but yeah, I was like, man, for some reason I feel like there's no like highlights. I feel like things are just kind of going along. I'm happy the way things are going, but nothing exciting.
Just kind of content. It sounds like you're just kind of content.
I guess, yeah.
It's not a bad way to be. We're also joined today by our special guest, Kim McDonald. Hi, Kim. How are you doing today?
Hi, Heather. I am doing well. I also am like Evan. I don't really have much to report in terms of life events, excitement. I think it's just work, eat chips and chippets, and rinse and repeat the next day. Just a lot of work going on. And this is the highlight. The podcast is a highlight for me to get together with you two, chit chat about the goings on in the legal world and other things. And I'm happy to be here and to fulfill my compliance obligations. For people who haven't been on our podcast before, my name is Kim McDonald. I'm a financial advisor and insurance advisor with McDonald Advisory at Raymond James LTD. So thank you for having me.
We're always pleased to have you, Kim. We were kind of all joking that I mean, for our listeners, they won't be able to see it, but we're all wearing stripes today, and that was not planned. So that's kind of a fun fact about today's episode. I don't know what it says about our mood, but someone can probably tell us what stripes mean. So we're here together today, and we're going to pick Evan's brain about wills and estates planning. What's a will? Why might you need one? So this is a topic that I actually often have questions about. So I'm really excited to be able to be asking you questions about this today. So maybe I'll go first. Evan, what is a will, and do you need one? Should we start there? Is that too broad of an opener for you?
Yeah, that is a great opener. What is a will, and why do you need one? So, first of all, a will, and it's a good question, Heather, because when I do estate planning, and usually I think when lawyers do estate planning, there's 3 documents here in Alberta that we prepare for our clients. A will is only one of them. The other 2 are a power of attorney and a personal directive. And we can talk about all those. The personal directive might be the least intuitive one because I think they call it different things in different jurisdictions. Personal directive deals with decisions regarding your health care and like end of life type things, and really anything that a guardian could do if a guardian was appointed by the court. And a personal directive can only come into effect when you become incapacitated, mentally incapacitated.
Okay.
Whereas a power of attorney deals with finances while you're still alive and can be immediate. It can be triggered by becoming incapacitated. And so in that way, it's a little different because if you think about it, if you're, as you get older, maybe you don't want to be the one always going to the bank and you have a child that'll help you out. You don't have to be mentally incapacitated before someone can act under that power, unlike the personal directive. And then to answer the question that you actually asked, what is a will? Mm-hmm. A will is a document that deals with your estate. And so that's all of your possessions when you die. And it also can deal with guardianship as well if you have minor children. So you can name guardians in your will. You can also do that in personal directive as well. So that's something to know.
Okay.
So a will is a very important document if you have children, minor children. It's very, very important because, well, Heather, you have children.
Yeah.
And if heaven forbid something happens to both you and your husband, who's going to take care of your kids? I want names. No, I'm just kidding.
Well, and that's interesting because I'm going to make a confession that I don't have a will. And as a lawyer, I know it's preposterous, isn't it? I have kids, I'm a lawyer, and it's something that just, Evan is rubbing his face right now with both hands. He cannot believe what he's just heard. I mean, I appreciate the importance of them, but it's the kind of thing where I think it's difficult for people. It's not a fun topic to think about. It's probably not fun money to spend. And then you kind of have to think about these hard decisions that you're trying to make about your kids and your finances and stuff once you're gone.
Don't you have any friends that are lawyers that could hook you up?
Yeah, I do.
Fun money to spend. Oh boy.
But it's really essential, right? So
yeah, it's super important when you have children, because I'm sure if you and your husband died unexpectedly and your kids were still under the age of 18, that you have family from one side or the other that would step up and everything would be fine. But they would have to go to court. They would have to go to court and be appointed as guardians.
Mm-hmm.
Well, and what if they disagree? What if everybody wants the kids and then there's some choppy waters?
Mm-hmm.
Yeah, and what if it's that aunt that you hate and who's so mean to kids and just wants to family child benefit?
The hypothetical aunt. I love all my aunties. They're all lovely, but absolutely. I'm sold. I'll do your intake. I'll do your intake after we finish the recording today.
Okay, I'll send it to you. And it's called the Estate Planning Questionnaire. I'll send it over to you.
Great.
So that's what a will is. And if you have children, it's really important. Even if you don't have kids and you have property that you want to decide where it goes when you die, a will is the way to do that. If you die and you don't have a will, we just talked about what will happen with the kids. Somebody will have to go and get a guardianship order. I honestly don't know exactly what that would look like and how that will work. Child welfare might get involved, and I'm not sure. It really would depend on the situation. But you wouldn't need a court order to like start taking care of the kids. But as soon as it comes to something like healthcare or anything else where the kids need a guardian to sign something, then you do need to be appointed by some kind of legal document. And if there's no will, then court's going to be the one to do that. So what happens then if you don't have a will, but you've got all this property? One question, we hear that a lot, and a common misconception is that the government takes it. So the government may take it. It depends. There's a law called the Wills and Succession Act that details exactly what happens if somebody dies without a will. There's these rules. It basically first goes to the closest, your property will first go to like the closest living relative. And then if they're not there, then it goes out to the next level, to the next level, to the next level. I'm not going to go into the details unless you really want me to, but and if there's none of those relatives, like it doesn't just say forever. It's like it's specifically names. And if none of those relatives are living, then it'll go to the state. When you die without a will, that's called dying intestate.
Okay.
And so you don't want to go intestate because it's just a hassle. And if there's a bunch of property, then someone's gonna have to go to court about it and become the administrator of the estate and then distribute it according to the rules. Anyways.
And in those situations where you pass away without a will and somebody's got to sort out what's happening with your kids and or your stuff, who's paying for that? Does that come out of your estate? Is it some, one of the poor souls that's left to pick up the pieces once you've passed away?
Normally it's going to be paid for by the estate. Yeah,
okay.
Normally. So, if somebody has to go to court to be named guardians, I'm not 100%, but it would make sense to me that the court would allow that to be paid out of the estate. And when there's not a will, you're probably going to have to ask the court that you're allowed to pay yourself out of the estate anyways. But I think they would. And usually
litigation having to do with the estate, often the estate pays for it. So,
if the estate is not liquid, then what?
Run away. Run away.
What does the executor do? Oh, by the way, the executor is the person who reads the will, correct? And follows the instructions on the will. Is that?
Yeah, so the executor is commonly the term used for both male and female now, but the old school is a female would be called the executrix, which I think is pretty cool, but people don't like those distinctions. But yeah, the executor is the person that's appointed by the will. Executor only exists if there's a will. And so the executor is a person named by the will as the person who's going to administer the estate. And so they're bound by the binding parts of the will. A will can also include parts that aren't binding, that are wishes. And so that are instructions that the executor can follow, and usually they do follow them if they can. An example of that would be how the body is disposed of. That's a wish. It's not enforceable because, what if it's just not feasible to what you wanted, and what if it would deter from the rest of the estate? The executor has to take care of the body, but how that's actually done is up to the executor. But that being said, normally executors follow the wish because they're like, who wants to dispose of a human body in some way other than that person wanted to be disposed of? Nobody. Everybody's going to do their best to, if they wanted to be buried, they're going to bury them. If they wanted to be cremated, they're going to cremate them.
Right.
So sorry, Kim, the executor, what was the question?
So let's say the money is just tied up, waiting for things to happen, but we've got funeral bills to pay. What happens to the executor in that scenario?
That's also a great question. And we're getting a little bit into an area of law that I don't actually practice, but I'm aware of generally how it works, because where I was trained, the person that trained me, that lawyer
loves estate administration. So he does a lot of estate administration. And so I got a front row seat and helped out on those files and have an idea generally how it works. So I can answer these questions, but I don't actively practice in this area. So if things like paying for the disposal of the body, those types of things can be paid for by the estate even before other things are sorted out normally. And there may be some process. In the worst case scenario, you have to get an order from the court. But usually it's the type of thing where the bank will release that money that's in a bank account that's otherwise waiting for probate. When they're provided, and probate, I'll explain what that is in a second, but the bank will normally release that money, the estate's money, to pay for the funeral. And so if you provide the receipts of from a funeral home or from wherever for disposing of the body, the bank will pay out of the estate. But your other question was, what if it's insolvent? Mm-hmm. So if it's insolvent, I said run away. I'm not joking. Nobody has to take care of an estate. No, it's not like you don't have to. If you're named under a will, you can say, that's nice and all, not going to do it.
Oh, okay.
And so when somebody dies and you're named as executor, one of the first things that you should do is go to a lawyer and have an initial consultation. And because, by the way, normally if there's money in the estate, normally the estate will pay for legal fees. And it's a reasonable thing to pay for out of the estate, even if the will is silent on it. You should have no problem reporting to the beneficiaries that you got legal advice of how to best administer the estate. It's a good thing to do. So if you go to see a lawyer and the lawyer sees that there is debt amounting to $100,000 and there's $50,000 of assets, normally the advice I think you're going to get is don't do it, just walk away. Because think about the complications there. And now you're working for the people that hold the creditors. Now you're working for the creditors. You're not working for any beneficiaries, because beneficiaries are going to get nothing. Right. So let me back up for a sec to explain why that is. There's like a hierarchy of things that get paid from an estate. And before beneficiaries get paid, all the bills have to be paid, all the debts have to be paid, all the taxes have to be paid. And normally an executor, to protect themselves before they'll pay a beneficiary anything, they're going to get a final tax bill. It's like not bill, but it's like a comfort letter, if you will, from CRA saying, okay, we're done. This was the last tax year and everything's been paid. Because who's on the hook if they screw that up? The executor is on the hook. And so first, all the debts get paid. In fact, there is a requirement, because of the requirement to pay all the debts, one of the things that an executor can do to protect themselves from any risk is advertise in the newspaper. This is a thing that still happens. You advertise in the newspaper for creditors of the deceased. And I think you run it twice for 2 weeks each time, something like this. You run an ad, take out an ad in the local paper. And then people have a limited time to come forward, creditors. And if they don't, then that absolves the executor from their duty to search for all creditors. Yeah, so I think that answers that question about if it's insolvent, don't do it.
I've also had I've had actually a couple scenarios where money just hasn't been available. So waiting for probate, can't get access to the money, the executor's got to pay bills, and it is coming out of their pocket until they can free up that capital. And to your point, executors are taking on some potential liabilities or cash flow issues when they take on that role. So it's a pretty serious cap to put on when you find out that you've been anointed executor.
Yeah, that's a couple things. You brought up a couple things that I wanted that I should mention. One is, first, let's tackle probate. Probate is some old-timey lawyery word that we use that just has to do with disposing of an estate. So when there's real estate involved, or when there's a significant amount of money in the bank, it doesn't have to be that significant either. And the bank is the one that decides that they want this. You're gonna have to get what's called a grant of probate if there's a will, or if there's no will, it's called a grant of administration. And that grant basically says, if there's a will, it says, this is the will. And that makes the banks feel warm and fuzzy inside, because now they know, they're not going to be on the hook if they give the money to the wrong person. You know what I mean? And land titles office just will not transfer any land of a deceased person without a grant of probate. They won't do it. And so that's an application that goes to court. The will is submitted, and there's all this other, it's really long. It's probably longer than it should be. They're in the middle of revamping all the court forms, actually. So I think the idea is making it simpler, because right now, surrogacy forms, that's, and I don't know why, okay, but the surrogate court is the court that deals with probate.
Right.
And their forms are just notorious for being terrible and getting rejections. In fact, there's a little industry built on automating these forms production. That's how bad they are. Anyways. So it's a little application that goes before the court where the will is attached, and it can either be contested or uncontested. And if it's contested, there's different forms than if they're uncontested. And then the decision comes back, the court makes a decision as to whether the will is valid or not. Most of the litigation you see about, the fighting in court about wills, is whether or not the will's valid. And usually it's reasons they're saying, well, Bill was just hanging out when Dad was old, and he got Dad to change the will. Undue influence, will should be invalid. Where usually the case is actually, Bill was the only one around. Dad doesn't like the rest of you anymore. Bill's getting everything.
Right.
which Dad can do. Okay, so that's what we talk about when waiting for probate, is waiting for that grant of probate, and it can take months. And so if there's really high expenses that need to be handled right now, and the only money is tied up at the bank and the bank won't let you have it, that's a problem. There's ways around that, but that can happen. And you're right, Kim, you've got to pony up the dough, and the estate will pay you back, but you're in trouble if the estate defaults, and you're taking on some of that risk. Oh, the other thing I wanted to mention, in Alberta, the default is, if you're going to be an executor, this is, basically everyone listening to this is going to be oh, being an executor is the worst thing ever.
Yeah, it sounds like a lot of work. It sounds like you're assuming potentially a decent amount of risk. You might be out some money, and that might be a task you want to do for a loved one, but maybe not everybody has the time or knowledge for that. So why would you agree to be an executor if not in addition to a love or family obligation?
Yeah, well, exactly, Heather. And it's funny because people preparing their wills get all cut up about oh, I want to name all 5 of my kids joint executors because I don't want one to feel left out. That's the worst thing you could possibly do.
Why?
Because
can't they just share the job and it makes it easier for all of them?
Yeah, they can share it. They've got to agree on everything.
Oh.
How many kids do you have, Heather?
2.
And well, I don't know if they're old enough yet to have disagreements, or do they agree on everything?
They probably wouldn't agree on whether or not they have disagreements.
Exactly. I have 5 kids myself. To have a situation trying to pick something to watch, and they're different age groups, so that comes into play. But forget it.
Right.
Very hard.
Right.
So yeah, kids can't agree. It's the worst. It's way better to just name one, and then an alternate, right? So if that person can't or won't, another backup, and you can have multiple backups, that's really easy. But having them do it jointly, that's like you saying I hate you to them.
As a group.
Yeah. Yeah. So, yeah, you're not doing anybody a great favor by naming them executor. I think that's going to be one of the big takeaways from this podcast.
Okay.
Well, what about kids in different cities or countries? Like, I know I've had questions on exams I've written on estate planning and whatnot, and there are issues with having kids who are, let's say, living in the United States and administering a will in Alberta. Is there, do people bring that up with their lawyers, or is it just, shakes out the way it shakes out?
So that's a perfect segue to what the next thing I wanted to mention, which is, if you are outside of, if you live outside of Alberta and you're going to be the executor, and maybe this is what maybe you're actually trying to pull this out of me, Kim. You have to, the default law is you've got to pony up a bond for twice the value of the estate. So, yeah. And the reason is the courts in Alberta only have jurisdiction over property in Alberta. And so they can't really come after you as the executor. It'd be real hard for the beneficiaries to come after you if you're living in Alabama. And so that's what the requirement for bond is for. So it's a double-edged sword here, because that law exists to protect the beneficiaries from bad acting executors, but it also creates an onerous obligation. And so if you've got a sizable estate, somebody's got to come up with a bond for double the value of the estate. That could prevent most people from being able to be the executor in the first place.
Yeah, does that include the deceased's real estate and stuff? So, if you have a parent that passes away with a $500,000 home, you'd have to somehow guarantee $1 million to be the executor. Yeah, that's
exactly. And so most of the time in wills that I draft, explicitly waive that requirement. Most of the time. In fact, I don't think I've ever written a will where I didn't waive that requirement.
Okay.
Because people are choosing people they trust.
Right.
And so usually they don't want to put that burden, that huge barrier to entry to being the executor. Another thing I wanted to mention is, we've just talked about all this liability that executors face. There is such thing as executor insurance. And it's that's another standard clause in the wills that I draft, that the executor is authorized to get insurance to cover them, because it doesn't just cover it's insurance. It's going to guarantee the beneficiaries are going to get what they're supposed to get.
Okay.
Right, and it protects the executor if they make mistakes, and makes sure that the estate isn't wasted. So, and those are really good examples of hey, well, it's just a will, no problem. I'm gonna do a holographic will, which we can talk about in a second. I'm just gonna write it myself, like that guy in Saskatchewan on the bumper of his tractor. Done. Yeah. Why do I have to go spend $1,000 with a lawyer? That's ridiculous. I just mentioned 3 or 4 things that are standard in my wills that you're not gonna put in your will that you write yourself, and that are gonna have potential to cause real problems.
Sure. I think I've heard that executors can get paid out of the estate. Is that true? Can they be compensated for their time and effort that they do put into administering an estate?
Let me throw that back at you, Heather. After what we just talked about, do you think they should be able to get paid?
Well, yeah. I mean, it does sound like it's a lot of work. You're hiring a lawyer, maybe going to lawyer meetings. It sounds like you're probably communicating with banks and land titles and real estate and a whole bunch of stuff. So
exactly. And yes, the law supports executors receiving compensation, and the law provides a range that is generally acceptable. the amount, and I think it's between 2 and 5% of the value of the estate. I usually put 3.5% in my wills and put it in the will again, so that it's right there. Nobody, because if it's not in the will, then guess what? The executor has to go either get it approved by the beneficiaries, and if the beneficiaries won't approve it, it's got to go to court, and the court will approve it. But you've got to go, and it's a hassle. Whereas if it's in the will, you don't have to get approval from beneficiaries. You just pay yourself that amount. It's right in the will.
Right. And that's just more delay and more money that's coming out of the estate that ultimately the deceased wanted to go to their family and not to the court, to a court battle or court application.
And nothing brings the best out of people like administering a will, like somebody dying and leaving money to the kids. Like, people just get insane.
Yeah.
They get insane. One of the most interesting cases I studied at law school was about the Foot estate. So the guy that donated Foot Field at the University of Alberta.
Okay.
That guy, he was loaded. And people fought long and hard about that will, and it's like the seminal will decision.
It's like the Alberta Bleak House, if there's any Dickens fans or listeners.
And of course, the part of the reason it was so interesting is he was living in Australia. Was he? So was he resident in Australia? Was he? I think actually now that I mentioned that, I think the reason I studied that was actually in conflict of laws, not in wills in the States. Anyways.
So lots of factors that we'll look at. Yeah. So, I mean, on that note, you've talked about executors. So that's the person that's sort of reading the will and carrying out the instruction. Then you talked about beneficiaries. So those are people that are getting stuff in the will from the deceased.
Yeah.
Can an executor be a beneficiary? Is that allowed?
Yeah, and it's very common.
Okay.
Right, because normally it's very common for people to name a child the executor, or their children as executor, and it's also very common to name children as beneficiaries.
Right.
So, yes, the way it works is, like I talked about, you're paying all the debts and the taxes, and then the next thing that gets paid before the beneficiaries is the executor's compensation.
Okay.
Yeah.
So that's in that order of operations, kind of.
And then the beneficiaries get paid out. Yeah.
Okay.
And normally an executor, when they pay out the beneficiaries, is before they pay out the beneficiaries, they send them a letter reporting to them and saying, here's a release. Sign the release and you'll get your check.
Okay.
And the beneficiaries, if they're happy with their review of the accounting, they sign the release and they get a check.
Okay.
On the topic of money, I think our viewers would be happy to know that Alberta is a pretty good place to kick the bucket. Our probate is quite cheap in Alberta right now, just over $500 for a pretty big estate. And I know in BC and Ontario they have there's a percentage of the estate as a cost for probate. So estate planning gets a bit more cute in those two provinces. As far as I know, Evan, is that your experience?
So I've never done I've only been involved in estate planning on the financial planning side in British Columbia. And it's a great selling point for insurance because, Kim, you can confirm this, but insurance has a very special standing as far as tax goes in Canada. And so to protect assets, you can put them into insurance products and avoid probate taxes in places like British Columbia. But I heard a rumor, I don't know if it's true. I haven't been following the legislative goings on here very closely, but I've heard a rumor that there's talk of bringing a probate tax to Alberta.
Interesting.
You heard anything about that, Kim?
I have not, and I read a lot of financial newspapers. That would be really important to know because I'm kind of in the high net worth space, and people would do a lot more interesting planning if they knew that was coming down the pipeline. Maybe multiple wills like they use in Ontario, or more life insurance potentially. That's fascinating, Evan. I'm glad you brought that up because I'm going to watch it a bit more carefully.
Yeah, I just heard it from the rumor mill. I haven't heard anything substantive yet, but What a terrible idea. And how un-Albertan.
Yeah.
Come on.
Sorry, I feel like you guys were geeking out there a little bit. So I want to back up that conversation a tiny bit. So I think what you're getting at is that, like, in other provinces where there's a probate tax, anything that's left in the will, so like the house, if that's worth $500,000, you might get, the estate's going to get charged a percentage on that when it gets probated. Why doesn't that happen with something like insurance? Does that not go through the estate or through the probate?
So I'll answer part of it and let Kim answer the rest. So anything generally, and it's like, I just read a decision. I think I mentioned it actually at our last episode or the episode before, this decision I just read about. Oh no, I didn't. Okay, I'll get to it. Generally, when there's a beneficiary designation, and so this is things like RSPs, you can designate a beneficiary.
Right.
Life insurance, you obviously designate a beneficiary.
Yeah.
Those, along with things that are held jointly, like especially in Alberta when you hold land as joint tenants, those pass outside of the estate and therefore avoid probate taxes. So in real estate, especially when the joint tenant dies, the legal fiction is that, you know, it immediately ceases to belong to that dead person and only belongs to the rest of the joint tenants or the last joint tenant. Kim, comments about insurance?
Yeah, you're bang on. There's one more thing that people use to get outside of probate, and they buy segregated funds. So they're mutual funds that have a little bit higher cost, and you can assign beneficiaries on those in money outside of registered accounts like RSP. So that's the only other little trick that people can use to keep their money outside of probate, as far as I'm aware.
Yeah, seg funds. Seg funds have other little features built into them too, usually by the insurance companies that sell them, and they're sold by insurance companies. Is that exclusively sold by insurance companies, Kim?
You must be insurance licensed to be able to sell them, but you can, advisors who are big investment firms or insurance companies, they can all use them if they have any kind of provincial licensing for insurance.
There you go. So, and I think probably seg funds aren't so popular in Alberta. In BC, they might be more popular for that very reason, as an estate planning tool. Because yes, there's other tools outside of your will that I don't give financial planning advice. Kim does. And so someone like Kim is a great person to go see for that part of it. When you get a will done up, the lawyer's not really concerned with exactly how you finagle things. In fact, a lawyer will tell you, hey, anything you can just sort out on your own and change and update without having it in your will, that's great.
Right, less work on the back end, sort of. And
yeah, so think about the executors, the poor executor. If it's in life insurance, they don't have to do anything. Provide the proof of death to the insurance company. The insurance company pays out to the beneficiary. Done.
Right.
It's like immediate. Right. I mean, it's not like the next day, but I think usually within a month or so.
Okay.
It's fast. File the final tax return, bada bing, bada boom.
Yeah.
Okay. Well, that's really good to know. I think that's helpful.
Okay, but I wanted to mention, so because I've just read this case. I can't even remember what province it's out of now.
Right.
I want to say Newfoundland, but I don't want to throw them under the bus if it wasn't them. It seemed to me like the wrong decision, which happens. But the decision was basically that it was a situation where a son was on his father's bank accounts and some other things as a joint so it was a joint bank account with the right of survivorship. Bank accounts have that distinction. You can say they're joint, but there's no right of survivorship. This was joint with the right of survivorship. And he was like helping dad out, kind of like you would with the power of attorney. I don't know if he had one or not. And he was not named under the dad's will. And there was another son also not named under dad's will who wasn't joint on these counts. Anyways, the court found that he was actually holding that money in trust for the estate.
Oh.
So what that means is, even though he had the right of survivorship that dad wrote and signed, the court decided, nah, that's not really what dad wanted. Really what dad wanted was for you to hold it for his estate so that it could be used to pay off stuff in the estate. So I think it's a terrible decision, and I hope it gets overturned in a court of appeal somewhere.
Right.
And it's not in Alberta, so it's not binding in Alberta, but it was definitely flagged because it's crazy. That's a crazy decision and would have significant ramifications across the estate planning world. Did you hear about that one, Kim?
I think we might have a form that we have to use now because of that particular case. So we have a gift form when people are JTW Ross on an account, so joint with rights of survivorship. There's an extra gift form to explain specifically that this is meant to be a gift for somebody, and we probably have that now because of the case that you're talking about, Evan.
Yeah, that's right, because they were saying it's not a gift, he's holding it in trust. Mm-hmm. So, which is totally ridiculous. Come on, court in wherever.
Oh, well, that is interesting. So again, I'm going to kind of maybe summarize that or break it down a little bit. You're saying that dad and son held this bank account jointly, and they explicitly said if one or the other one passes away, this bank account is meant to go to the other person. It's just, that's going to be theirs. But then when the dad passed away, the court said, no, that's not what they intended. What they intended was that the other person is still holding it for dad in the first place, which is, it sounds like it's a little bit of a fiction there that they used to get there, but that's interesting. Well, I'm curious to read that case.
It's kind of like,
see how they got there.
Have you ever listened to Flight of the Conchords?
Mm-hmm.
So they have this song called Business Time.
Yes.
And there's this line where he says, you said, is that it? I know what you're really trying to say. You're trying to say, yeah, that's it. That's kind of like what they did here. It was like,
right.
I know you said that not only were you holding this in joint, but the person had right of survivorship, meaning it's theirs when the other person dies. That's not really what you meant.
Right.
What you really meant.
What you really meant was.
And I didn't read the case in detail, so maybe there's some more there that informs that decision, but it's on the face of it ridiculous. But luckily, as Kim said, the financial industry is already trying to do their best to make sure that doesn't happen again. And this is what usually happens when courts make a decision like this. A good example in the family law context is spousal support. People think they contract out a spousal support. Court says, nah, you almost did, but because of this. And then they're like, fine. And now all the contracts have to say this new thing because...
That's right. Our spousal support waivers are 3 pages long now for all the possibilities, right?
Yeah.
So what about public knowledge on estates? I know in divorce, there's certain avenues that people pursue so that way things aren't public knowledge. On the wills and estate side, it's my understanding that people do some fancy estate planning sometimes so people don't know how much money they have and can't look it up. Evan, do you have any?
No, I don't know, Kim. That is a question I do not know the answer to. Now, generally in court proceedings, you can, like I'm thinking about in family law, there are situations where you can have like a publication ban and make it, and they do it in criminal law all the time, especially when minors are involved in sexual assault or just in general. Those are like immediately, like you don't want some psychos out there, getting enjoyment or something from reading about sexual assault or inspiring other people to commit similar copycat crimes. And so it happens in family law as well. But the question is good because by default, court is public record. That is the whole point. That's a really important tenet of our justice system. So how to keep things private when you go to court, I don't know.
Do 2 wills. So one will plays out a certain way with certain assets, and that would be public record. And then another will, I know they do this, I'm pretty sure they do this in Ontario, and then another will would have different assets, and then it wouldn't be part of the public record. I don't know. I was just, I don't know much about it, but I'd heard this and never investigated. So I thought.
Yeah, no, that's a good question. I don't know if like you or I could just walk into court and do like a search at the surrogate counter or like through the surrogate court for like a will. You'd have to know more, like you'd have to know who you're looking for, first of all. I don't know. I don't know what that would look like. So it's a good question.
Yeah, I mean, in family, they've changed the search so that on Family Matters, you do have to file that form that you're involved in the matter, right? Lawyers have to sign off. People can't just go searching now for things, but I wonder if the surrogate court has done something similar or has always had something similar.
Yeah, that's a good question, Kim. Not sure.
And after divorce, do we update our wills immediately? Does divorce void a will? What's that scenario?
Oh, such a great question as well, Kim. So part of that is going to depend on the separation agreement, or whatever you call the agreement that is dealing with your property and everything when you get a divorce, because you can put terms in that agreement that kind of deal with that so there's no emergency. And you can deal with it one way or the other. You can say any gift made by the other in a will is no longer valid, let's say, for, like, I don't have the wording memorized. We say it a better way than that. But basically saying, no, I don't care if my will says I'm leaving everything to my wife. This agreement is saying that's not happening anymore. Even if I don't change my will, that's not going to happen. And you can also have it say the other way, where like it doesn't affect the will. Because if you're intestate, so there's no will, then there's important legal consequences to getting divorced and separating. And I'd have to look it up to tell you exactly what what those consequences are. But if you have a will, the default is the will is still going to apply. So depending on what the agreement says, that can change that. But ultimately, if the agreement just says, no, any gift we leave to each other is no longer valid in the will, you have to look at your will because you might be intestate. It depends what your will says. So it's a combination of the two things, and we'll determine on how urgent that matter is for like getting a new will. But when you get a divorce, anytime you have like a major life change, when you get married, when you get a divorce, you should be changing your will. As your kids grow up, you know, things change. Like it becomes less, as they become financially established, it becomes less important maybe for you to be leaving a bunch of property to them. You may have other people you want to leave it to. Yeah, so I always recommend to my clients that every year they pull the will out, blow the dust off, read through it again, make sure that it's still appropriate for their situation, and if not, give me a call and I'll help them deal with it. I also try to draft them so that you know, they don't have to change them ever if possible. So they, you know.
I guess that's another question that our listeners might have. How long does a will last for? Is it just good for 5 years or 10 years or however long it says?
So wills don't normally have an expiration date.
Okay.
Because they don't even they don't even mean anything until you die.
Right.
So forever.
Right.
Is the answer.
Yeah. So if you don't change it, it's just going to stick around there and continue to say what it says and be valid. Okay.
It's a really important document to keep track of. We talked about probate and having an application for probate before the court. So this the Wills and Succession Act is relatively new. And one of the things that it brought in is this ability to fix deficient wills. So first, it defines what is a valid will. And there's like technical requirements, and there's three different types of wills that can be valid. Then it has these curative provisions, we call them, or provisions that allow somebody to fix an invalid will. And that's new to this new act. And so that allows people to take a will that wouldn't otherwise be valid and go to court in an application to get it named as the valid will and to get that grant of probate. You don't want to have to deal with that. You want it just a valid will that is a no-brainer desk application. Nobody has to go and give evidence about the person's intention at the time they wrote it.
Right.
And whenever you make a will, you got to destroy the old will. And so you also want to destroy copies because copies aren't valid. One of the requirements for a will is that it's the original. There's only one. Photocopies of a will are not valid.
Okay.
And if there's any writing on the will, invalid. So you can't just be like writing on your will because now it's screwed.
So it's not just that additional writing that they don't look at, that just invalidates the will entirely.
Yeah, don't do it.
Okay.
Don't do it.
Good to know.
And so if you could see a situation where you're going to update your will a few times in your lifetime. Maybe you've got 3 different wills floating around. The new will always invalidates the older wills. But you don't want people to be confused about what you want to set out in your will. So like, I don't know.
Maybe. Yeah.
I don't
Maybe
know for my clients. Like some lawyers do, or they did in the past. They've got like safes full of wills. I don't do that. They go to the client, takes them. They're my client's responsibility to look after them. And I take, when I'm doing a new will for someone that already has a will, I tell them to bring me the old will, copies, and I destroy them for them.
So if you are, you go to a lawyer, someone like you helps you write a will. Is there anything else that a person can or should be doing to make it nice and easy for their estate if they pass away? Should they keep a list of their bank accounts, their debts, their wills all in one place, their life insurance policy? Like, is there kind of like some practical nuts and bolts bits? Because it sounds to me like Auntie Rose could like come into my office and maybe find, will number 2 of 5 that I have and say, well, here it is, stop looking. And that might not actually be my wishes. So
Yeah, great question. Great intuitive advice, Heather. Yes, that's what I tell all my clients as well. Keep a list of everyone that needs to be notified in case you die or that something happens to you, because again, it's not just the will that will be with it. It'll be your will, power of attorney, and personal directive. Keep a list of people that you want notified. Keep your most recent bank statement. It doesn't mean every month you have to go and put a bank statement. Just do it once a year. When you pull it out and blow the dust off, also update all this information. Insurance policies, bank statements, any assets, information about where they are, all that stuff, keep it in one tight little package so that then, yes, the executor will be like, I feel very confident. I've got all of the debts here, so I don't have to run ads in the newspaper because nothing's going to come of it anyways, because this person was very well organized. Yes, keep it all together, and once a year, go back and update that.
I'm thinking like in today's day and age too, where so much stuff is online, people aren't, you don't have your big old filing cabinet with your bank statements in a paper stack. So if someone finds your will, and it's great that it's all left to so-and-so, but what's all left to them? Is the estate having, like, they're trying to find all your bank accounts then and all your investments, and that could be tough, right?
You send them to all the banks. I mean, luckily there's not that many in Canada.
Yeah.
But,
if they can't open my iPhone, I think somebody's going to have a pretty hard time figuring out where my stuff is. So, yeah.
And that's another thing today. Everything is more and more digital. I just wanted an update. I just found quickly in the Wills and Succession Act about what happens if you're intestate and separated. So for the purposes of if you don't have a will, you die without a will. If you're separated, the separated spouse is deemed to have predeceased you. So that means they're out of the distribution. Even if you're not divorced yet, you're just separated. Now, lots of, like, I'm sure you can find court cases where someone fought about how separated they really were. Once he died, or once she died, well, we were back together.
Right.
Again, that only applies if it's intestate, because the will supersedes the intestacy rules in the act there.
Okay.
But
Okay.
yeah.
So let's talk about costs. I love talking about the price tag on these things. So I would say 90% of people under 50 years old who contact me for financial planning do not have a will. It is very common. The reasons they all say, I mean, a lot of them is dragging their feet, but a lot of it too is the cost of getting it done. So Evan, I'm curious, what can we look at for fees? And you alluded before to holograph wills and what a mistake they are, and probably will kits kind of line up with those. What should people do when they don't have very much money?
Well, first, I love your choice of words. And as a linguist, I probably love words a little bit too much. But what is the cost? What is the cost of getting a will? What is the cost of not having a will? Is the same question, I would say. So the cost of not having a will can be thousands and thousands of dollars. If your estate is gonna have to go to court to argue, you're at least gonna be paying $3,000 to $5,000, at least, and run the danger of things not going the way that you wanted them to. And if there's no will, and they're just, someone's going to become named the administrator of the estate, again, $3,000 to $5,000, and the estate's paying for it. So that's the cost of not having a will. The price that you pay for a will varies a little bit from lawyer to lawyer. I charge just under $1,000 for a will, for estate planning package. So that's a will, personal directive, and a power of attorney. It's $950 plus GST and disbursements. Disbursements would be in estate planning would be things like title search, which is $10 per property. Usually not, maybe a corporate search if there's a corporation involved, which again is something like $10. So disbursements aren't huge. It's generally about $1,000. And if it's what we call a mirror image will for the spouse or partner, which is basically says the same thing, just names are swapped. Otherwise, the will's the same. It's $300 for that second estate planning package. So that's what I charge, and I think you can find cheaper, and I think you can find more expensive, but somewhere in that range is what you can expect. And I don't know, it's up to you whether you think which cost is higher. That's a decision that everyone can make for themselves. Look, I'm lucky, right? I was a summer student working at a law firm and got my will done for free. I was lucky, and I didn't have one before then, and I already had 3 kids. So actually, I already had 4 kids by the time I had a will. And I'm like, no property. Nobody's going to be fighting over becoming the executor of my estate at that time, as a law student with 4 kids in the middle of gathering student loan debt. But it's really important about where my kids go and who's going to take care of my kids.
Yeah. It strikes me that there's like an emotional cost savings as well. I mean, there's the part that that you've put your wishes down, but you're saving, those people that you're leaving behind probably a lot of emotional stress at a time where they've lost you, and they're probably already pretty sad, upset, and they don't want to be making legal decisions and court applications. And that kind of thing. So
yeah, you're right, Heather. I mean, just think about the stress of, okay, mom died. Number one thing you have to take care of, disposing of the body. What did mom want? We don't did she want to be cremated? Did she want to be buried? Are we doing a funeral? Or are we doing a memorial service? What one would she want? And then you go to a funeral home and they're like, hey, did you love your mom?
Right.
How much did you love your mom? Look at this coffin. I don't want to disparage funeral homes. They serve a very important service, and I'm sure not all of them are like that, but some certainly do. Some certainly prey on the grieving family to up that purchase to the nice granite obelisk. Because don't you think mom would have deserved? Don't you think she deserves the obelisk?
What about a cost to update the wills? I think that's called a codicil. What is there, like a deal kind of thing?
Yeah, codicils normally are much cheaper. It depends what you need to do. Often, wills aren't just updated next year. Usually it's 10 years down the road, in which case I'm like, we're going to do this from scratch because the laws changed, / the precedent I'm using now is just better than the one that was used 10 years ago for a number of reasons. We're just going to do a new one because it's just going to be better. But not always. Sometimes a codicil is suitable, and you're looking at, I don't know, $300 to $500 maybe.
And a codicil is sort of an will add-on. It's like an extra. Okay.
Yeah.
Let's talk about the questionnaire. And then this is where all my clients seem to get stuck. They'll go to the lawyer, they'll get the questionnaire, they'll file it away and never finish it. What is the trick to getting the information to the lawyers?
So I guess some people get hung up on the questionnaire. I'm thinking about my own clients or people that have called in and started. Most of the time it's not a big deal. And I don't know if that's because my questionnaire is easier than other people's questionnaires. Mm-hmm. I inherited that questionnaire from the people that trained me, who were kind enough to allow me to take it with me when I struck out on my own. So it's not like I created this thing on my own. It's been created and updated and tweaked for years and years by some people who do really great work. So I'm not taking credit for that questionnaire if it's a really good one. But I don't know. Look, but what I can tell you is, questions I get about the questionnaire sometimes is why do you need to know all this stuff? Why do you need to know my assets and liabilities? Uh-huh. And, do you want legal advice about what to do with your estate or not? Because if you don't want legal advice, then I don't need to know anything, and you don't need a will from me. But of course, if I'm going to provide legal advice about your estate, I need to know what is in your estate. And that'll also help me flag things potentially for you to go see Kim about as well, or your other insurance broker, if you're not in the prestigious level of Kim's clients. What I mean by that is Kim's awesome. Not that she only takes good people or better people than others. Anyways, so it allows me to flag potential issues as well. And it's pretty comprehensive. So I need to know all the assets, all the debts, all the real estate that you hold, all of that kind of thing, those kinds of things. I want to know your RSPs and your TFSAs and your pension and all this stuff that doesn't even go in the will. I just need to know about it so that I can give you advice properly, so I can see the whole picture. Because otherwise I can't really provide good legal advice.
Is that where folks are getting hung up on, Kim, in your experience, is getting those financial package together to get to their lawyer?
Yeah, it's probably very similar why people drag their feet on the property statement and divorce. They don't know where things are. They don't know what they have. And they just, rather than figure it out, they'll just push it aside and watch Netflix because it feels better. But it is a good reason to have a financial professional you work with, because I can tell you from my own clients, I know where all their insurance policies are. I know they keep their will in the freezer. I know all this stuff. So if they just come to me, I can just push the information their way and just say, send it to the lawyer.
My parents keep their estate planning documents in the freezer. They got this old school lawyer to give them a deal on it in their older age, and he told them to put it in their freezer. I don't I think that's funny. Is it because of
fire?
Fire, yeah. The freezer will last.
Yeah, it's lined with lead. It's I'm thinking about Indiana Jones, where he jumps in the fridge during the bomb blast. don't know, but
I guess if you can't have Harrison Ford take care of your will, then you may as well.
yeah. So there's a couple of things that I think are important to touch on questions I get all the time, which is one of the things on the questionnaire is about a trust. Now there's two types of trusts. One just became legal in Alberta like 2-3 years ago, called a Henson Trust, which is commonly had been used in Ontario. This is something that only applies where a person is a represented adult. And so it's very niche. I'm not going to talk much about it, but that's one type of trust. The other is you can't give property to minors. I tell this to my kids all the time. You don't own anything, kids. All belongs to me. They can't hold property in Alberta. Minors can't hold property. And so where you're leaving property to a minor, or who could potentially be a minor at the time that you die, then you need to establish a trust. Your will needs to establish a trust. It's not like a super complicated thing to do, but it needs to be done, and there needs to be things set out. And so like, what's the purpose of the trust, and how can the trust be administered, and what can it be used for? You need to provide direction to the trustee, whoever's going to be operating as that trustee, and you need to name who the trustee is going to be, or who the potential trustees are going to be. And usually it's the same as the executor, but not always.
What does a trust do, Evan? Like, you basically say like, I want to leave my estate to my kiddos, but they're 10 and 8 right now. So my sister is going to hold that money for them until they're 18.
Yeah,
like
exactly. And when you're establishing a trust in your will, it doesn't have to be 18. You can set that age to be whatever you want.
No, it's got to be at least 18 though, I'm guessing.
At least 18.
Okay,
that's right.
But it could be 25 or.
Yeah, and you think about it, like if I do die and I'm leaving like $200,000, Sally, and right now Sally spends all her extra money on Barbies and Freezies.
Yeah.
Well, maybe you're worried she's going to go buy a car when she turns 18, a nice like Corvette or Lamborghini or something.
Really nice car.
Yeah. So maybe you want her to get a little more wisdom first before she gets all that dough. So. It doesn't have to be 18. It has to be at least 18, but it can be any age that you choose.
And then does my sister get to just dole out the money however she wants to? No. Okay.
Unless you say that, unless you give her that authority. So in your will, you'd establish the rules of the trust.
Okay.
And the wills that I draft, usually it's pretty broad authority, because you don't want to tie their hands too much. You want them to take care of your kids.
Right. And
so you give them the authority to treat each kid uniquely, right? They don't have to treat them the same. And to use the money for things like school, clothes, food, shelter, including buying a bigger house, if you need a bigger house to house all those extra kids, this kind of thing. Really broad usually, because that's generally what people want. You want to make sure your kids are cared for, and you're trusting who you're naming as a trustee to do it, and to still have some money left, if at all possible, for them when they're older.
Okay.
I've seen it before with adults. So my own clients, for example, would have a daughter who marries a guy they don't like. Maybe he's a gambler, maybe, I don't know. They don't like him. So they create trusts to protect the assets from a divorce. How often do you see that, Evan? Is that common?
I've never drafted a will with a trust for that reason, but you could. You definitely could, because now, that being said, inheritances, Heather, as you well know, are exempt from matrimonial property division. And family property division.
Family property.
That applies to more people than just those that are married.
Yeah.
So there's not a huge danger there, unless your child puts it in a joint asset, then they immediately lose half of that exemption.
Yeah.
And that's on them.
Yeah. Or if they cash it out and put it in their bank account and boyfriend spends it, I guess, then it's gone. But
yeah. In fact, I have a client who that kind of happened. She got a nice sizable early inheritance from her parents. Her parents are still alive, and had it sitting used a big chunk of it to pay down the mortgage, and then husband took a big chunk of that and put it in some questionable investment down in the US. That's probably, the money is probably gone. So that's so that can be a challenge. But in Alberta, I just don't, based on the law, I don't think it's really crucial that you set up a trust. But you for sure could.
So definitely important to educate your kids if they're getting an inheritance and they don't want it to go to the spouse, potentially they need to be careful not to commingle it with other monies.
That's right. Because the minute you do, you lose half the exemption. You don't lose all of it, but you lose half of it. It's then deemed like a gift, like you're gifting it to your spouse. Yeah, and I think what my wife plans on doing for our kids, I don't know if she will follow through on it or not, but like as an engagement gift, she's going to buy them pre-marital counseling. And she got this idea because she was listening to some podcasts, and someone who does this premarital counseling, and something like 50% of the clients end up not getting married. And so it's like bullet dodged.
It's not a bad idea. We always say everybody prepares for the wedding and not the marriage, right? So
that's what marriage.
Not a bad idea to flip that around.
Another thing I wanted to mention before we run out of time is another common question or preconception people have about wills is you got to put in all the gifts there. Like, okay, my Harry Potter collection to Bill, and etc.
Yeah.
Pretty much, I never do that. So very occasionally we'll name specific gifts in a will, usually not. And the reason being, if you don't have that gift anymore when you die, it's not like, like a house, for example. Let's say you sold that house and bought another house. The new house is not going to be covered by that gift of the old house. And so that has a possibility of leaving part of your estate outside of the will and being intestate. And you have like partially covered by the will and partially intestate. And also, then you'd have to like update the will more regularly. So what we do instead is generally have like a general gift of the entire estate goes to whoever. And if you want to go to multiple people in different percentages, then you set those different share points for each person, and you divide it out that way. And there's always an option to include a memorandum with your will, which is not legally binding, but it's, again, shows your wishes. And the testator is usually, or the executor is usually going to follow your wishes. And so we leave a memorandum with the will where you can set out, like, I want this particular thing to go to this person because of sentimental reasons. And then if that changes, maybe you date it and sign it and stick it with the will. And every year you look at it when you're looking at everything and decide if you want to update it. And if that changes, you can just get rid of that memo, write a new memo, put it with the will. Don't have to get a whole new will. So like really nice jewelry, paintings, things like this, unless it has sentimental value and you're, really confident it's going to be around, you really don't waste your time putting it in the will. Just put that in a memo with the will.
Okay. And you can leave those kinds of gifts to people that are not listed as beneficiaries.
Well, yeah.
Yeah. Okay.
Yeah, that's right. That's right.
Okay. Interesting.
Okay, another thing that people would not necessarily think of that's like just standard with a lawyer preparing a will for you. There's this form called an NC8. And NC is a prefix for surrogate forms where people are not contesting the application. Non-contested. The contested ones start with a C.
Oh.
An NC8 is an affidavit of a witness to a will. And so you don't need, an NC8 is not part of a will. If the will's all signed, that's the will. But if you're going to go do a court application about the will, you're going to be hunting for one of those witnesses to get them to swear an NC8.
Oh.
So obviously when you get it done by a lawyer, certainly I've always only done it with an NC8. I think most lawyers that do estate planning, I think all of them would do this in Alberta, but they'll swear an NC8. So if I'm acting as one of the witnesses, then I'm going to swear an NC8 to my assistant, and that affidavit, technically the will gets attached to that affidavit as an exhibit to the affidavit. And that affidavit is just a sworn statement that is, it's like a portable form of evidence, like travels with the will. So if you ever have to send it to the court, you don't have to worry. That's one less thing you have to worry about. Again, it's about making it a little bit easier for the executor.
Right.
I've read a lot of my client wills, and I don't think I've ever seen an NC8 stapled in. That's very interesting.
Mm-hmm.
Tell them to smarten up, Kim.
Smarten up.
It could be tough, right? Because like, my principal, the lawyer that trained me, I definitely remember him administering at least one will where there was not an NC8 with the will, and we were like trying to hunt down the lawyer who acted as a witness and prepared that will. Couldn't find the other witness. Like they were moved to the States, maybe it died. And guess what? The estate was paying for the lawyers to like do all this hunting around.
Right. Yeah. And it's not uncommon, right? Like to have a staff of a law firm or something to be a witness, right? So, yeah,
exactly. And I mean, it could be for any reason, right? Like, I don't know how long the NC8 form has been around. So if it's an old enough will, maybe it just wasn't common practice at the time, but it is now. Let's talk about holographic will. Kim, you made allusion, and I made allusion to holographic will. It sounds cool. I always just picture like Princess Leia asking for Obi-Wan Kenobi's help. A little holograph. But it's way less cool than that.
You're our only hope.
Yeah. Help us, executor. You're our only hope. A holographic will is the term that we use for a will where a person makes a will all in their own handwriting. Nobody else is writing on it. It has to be all in their own writing, signed by them, dated by them. That's as long as it deals with the estate. Sometimes that's another thing that has been seen by lawyers is a person does a will with a will kit or they do a holographic will and it doesn't actually dispose of the estate.
What do you mean?
Well, they just don't do it. They don't give it to anybody.
Oh, no.
So anyways, so a holographic will would be like, I, Evan Clarke, leave everything that I own to Heather Malarick. April 29th, 2021, signed Evan Clarke. That would be a legally binding, terrible idea by myself. My wife would not be happy.
No.
But
she would probably not be your executor.
No, I didn't name one. That's the thing. So now you got this holographic will, and in order to get at my stuff, Heather, you're going to have to go and get a grant of administration. So that's what a holographic will is. And they can, like, I just gave a really simple example. They can be super complex. You can just write it all yourself and sign it and say it's a will, and it will supersede any other will that you have. And, one of the challenges of a holographic will is, and the reason we have this in the law, I think, is I also made reference to that Saskatchewan guy who wrote it on his bumper.
Yeah.
So background, this farmer, really muddy, gross day, got trapped, like tractor stuck or something, got out to fix something. It all went wrong. He got trapped by his tractor, pinned. No cell phones, couldn't get anybody. He had like a knife or a screwdriver or something, and he like etched in the bumper, which is housed in the University of Saskatchewan's law library. He etched in this bumper his will. And obviously it was really simple. I don't know what it said, but it was like, I leave everything to Julie.
I think it was like all to Rose or whatever his wife was, I think, or something like that. It was very short. Yeah.
And so the court found that to be a valid holographic will. And I think that's the reason that we want to be able to, like, at the last minute, on your deathbed, you want to make a change, you can do it. You just have to write it all in your own handwriting and sign it.
Right.
The other one is a military will, which I'm in the military. I don't really know what they're getting at by this, because the military doesn't really do wills, and the military will that I had before I had my own will was just garbage.
Okay.
So no, is the answer to that
Just
one.
don't do it.
And then the other one is like with all these technical requirements, which may as well tell you what they are right now. It's not that complicated. The technical requirements are there have to be 2 witnesses. The witnesses, neither witness can be a beneficiary. And can't be the executor either.
Is this for the military will or the holographic?
No, the real will, not holographic, not military, the real
Okay.
will. Can't be a beneficiary. I just want to double check about the executor.
I'm thinking that Heather should be drafting a holograph will right now that we've determined she doesn't have a will.
I mean, you probably haven't seen it, but I have been. I've just been writing out.
Just pull it out. Find it.
Yeah, like, it's better than nothing, Heather. Anyways, I will double check about, but I'm pretty sure the executor also can't be a witness, but I could be wrong about that. I would need to double check. Regardless, 2 witnesses, the testator, the person making the will, and the witnesses have to initial the bottom of every page and have to sign the last page. And then optional, you get that NC8, which is an affidavit that one of the witnesses swears, saying that they were a witness and they witnessed the, you can download that form off the internet.
Yeah.
And NC8. So those are the legal requirements. And if they're not met, then it's not a valid will, and it would have to, the court might find it a valid will, but you're going to go argue about it.
Right.
Was I saying something about that? I don't think so. Just
No,
the
we were just
wills.
talking about the different kinds of wills and.
Yeah, and so be very cautious about getting any kind of a will kit, because wills, anything to do with property in Canada is governed by the province. And so there's changes from province to province. The rules in British Columbia about wills are different than the rules in Alberta. And same thing for all the provinces. They're going to be similar, but not the same. And so what I just said about a will being valid, that's only in Alberta. I don't know if that's the case in British Columbia or any other province or not.
Right.
Yeah, so it's buyer beware. It's like we talk about agreements, Heather. It's the false economy, thinking you're going to save some money on doing the will yourself because you spent $50 on a will kit. Well, you got what you paid for. You got a $50 will kit.
Right. Right. And while something might be better than nothing, at the end of the day, you're maybe not getting what you actually want.
Yeah, exactly. And I hope that what we've talked about here today at least gives you an idea of why it's money well spent when you're hiring me or some other lawyer that does estate planning and you're spending $1,000 on a will. It's not just a glorified version of the will kit. It's something that's custom made for you. And also, like, all the things are in the wills that I draft because of years and years of estate administration and seeing what happens, what has happened on those files, and the problems and the changes to the law and like ways to make sure that it really is going to be the best will that it can be, kind of thing. It's not just a one and done type of thing. I inherited my will precedent from the people that trained me, and their experience. They've had tens of years experience, and I don't know that, and all the influence that they've had as well. It's years and years and years of legal minds. That's what it's a product of. It's so, and whatever lawyer you have drafting your will, it's going to be a similar situation. It's not just something that threw together one day. It's something that's been passed down from lawyer to lawyer through the ages.
Yeah.
And there's benefits to that.
Yeah, absolutely. Well, you've got me convinced. So I'm gonna get off my butt and I'm gonna get my stuff together and get a will. I mean, it is the one guaranteed way we're going to interact with the legal system, all of us. So, I think it does bring me some comfort of the thought that if I were to pass away, that the people around me would know what I want, that it would be as easy as possible for them, and that it would all be taken care of. So
Yeah.
thanks for answering those questions and for getting
You know,
it back on my to-do list.
I'm glad I could help. And yeah, I'll send you that questionnaire, Heather. You fill it out. Let me know when I can help you. And Kim, I'll send you the questionnaire as well, just in case, you know, your clients are intimidated by a questionnaire. And like, they don't have to just use me because they used my questionnaire, even though it is a branded questionnaire. They could take that to any lawyer, I'm sure, would accept my questionnaire. It's got all the information they need, so.
I think maybe people just seeing the questionnaire might give them the confidence to go and get the will done. So a lot of times it's the not knowing, like the unknowns that stop people from doing things. So maybe we can get that questionnaire posted for people listening in today, and they can just have a read through and then just tackle it.
Absolutely.
So I feel like we almost, I know we've been on here for a while, we'll probably be closing this down soon, but Evan, will you come back another time so we can talk about powers of attorney and personal directives? Because I've got a whole swath of questions.
You know what, Kim? I'm coming back next week. We don't have to talk about that next week, but I will be back here next week and every week. And so, yes, of course, anytime you want to talk about those, I would love to. Yeah, just say the word.
Sounds good.
And,
you know, sorry, you go ahead, Evan.
okay, I just wanted to update about the technical requirements of a will. So, what's required is that a testator makes or acknowledges his or her signature in the presence of two witnesses who are both present at the same time, and each of them sign the will in the presence of the testator. And it can be a beneficiary and can be an executor. So I was wrong about that, but it's better if it's not, simply because I think executor is less of a problem, but beneficiary, certainly that's gonna just raise questions about intent and influence. And so it's definitely better practice not to have a beneficiary be a witness to the will. The military wills, I just wanna clarify, as I said, the military doesn't really do wills. They have this dumb piece of paper that you can sign, that's a military form. But what it means by military will in the Wills and Succession Act is, if you're a member of the Canadian Forces, while you're in active service under the National Defense Act, so that's going to be a defined term. I'm not sure exactly what that is, but definitely if you're deployed, for example. And you can make a will by signing it without the presence or signature of a witness or any other formality. So if you're in the military, you can just do whatever you want and call it a will, as long as you sign it. So if you're active service in the military, it's the Wild West as far as wills go. Have at her.
Does that mean they don't have to handwrite it? They could type it and then
Whatever
sign
they
it?
want. Whatever they want. They can make a will by signing it without the presence or signature of a witness or any other formality. Any other formality.
That's interesting. So I imagine that's geared at like those exigent sort of circumstances, right? You might be in a situation where the end, you feel like the end is near, and getting that down is better than not. So
exactly, and I think they're just the point is, when you're in the military in active service in the presence of the enemy, it should be even more relaxed than if you're on death's door doing a holographic will.
Right.
I think that's the policy reason. I mean, I didn't read the Hansard, so I don't know for sure, but it makes sense, right? That is a special example where it's special circumstances. And just keep in mind that the challenge is always going to be, if you don't have like the formal will, the challenge is always going to be, well, who's going to accept it as a will, and proving it in a court application if it's tapped, right? So the formal will is always the best because there's all these safeguards in place, and to make sure that it's a proper will and there wasn't undue influence in this type of thing. There's all those safeguards set in for that purpose.
Right. So that things go as smoothly as possible.
Yeah. So that's my closing thought. Just a quick correction on what I was saying about military wills and the formal requirements for signing formal wills is what it's called. Yeah. Any last comments or questions from the peanut gallery?
No, just thanks so much for sharing your knowledge about that. And I was saying during our break that I'm going to go and talk to my parents and in-laws now too about where their wills and all their stuff is, so that, you know, I can be prepared if and when something happens to them.
Yeah, my parents, like I said, they keep it in the freezer, and they named me as executor, and I said, thanks, parents.
Well, at least not along with one of your siblings, hopefully.
I'm just hoping, no, it's not. I'm just hoping they spend it all.
Yeah, right. That's the
like,
dream, right?
Yeah, because first of all, like that should be the goal anyways.
Yeah.
And like, we're all grown up. My youngest siblings are in their 30s. So, I mean, there's a lot of us, but we're all grown up. So it's okay, mom and dad, we've moved on.
That's right. Go have fun.
Yeah, exactly. Spend all your dough while you can. And there's 12 of us. So like what, so imagine they save $50,000. That's like a couple $1,000s each. You may as well spend it on something cool.
That's right. That's right. They'll enjoy it a lot more than you'll all enjoy a 12th of it. So
Exactly.
yeah.
Kim, any?
Yeah, I'm just sitting over here, all the little things that I still have questions about, but I mean, we can't go, this has already been long enough today, but things about hiring trust companies to manage your estate or powers of attorney, personal directives, all this good stuff. I think we definitely will have to come back on here at some point and address those other questions. But today I think is a really good starting point for people who have a will and haven't read it in a while, who don't have a will, who have a holograph will and they forgot to update it to a real will. There's just so many reasons for people to listen in today and take action.
Yeah, and I think we should also hear what you have to say about it too from the financial side, because there's a lot of things there that we didn't even come close to getting into, because you know there's so many things that you can accomplish and plan that have nothing to do with your will.
Yeah, you mentioned early inheritance before, and that's something that like perked my ears up that I want to know more about. And I'm sure Kim's got a lot of info about that. So yeah, we put lots of pins in today to come back to in the future.
Well, thank you guys. This is great.
Lovely to see you both as usual.
Yeah, well, this has been Access to Justice. So come back next week.
Next week,
on the streets and time.
Any information in this video is general information only and is not, nor is it intended to be, legal advice. Watching this video does not create a lawyer-client relationship. You should always seek the advice of a lawyer or other qualified professional for advice regarding your individual situation. While we take care to ensure that the information contained in this video is accurate and up to date, we make no warranties or representations as to the suitability, completeness, or accuracy of the information contained in this video. Any reliance you place on the information is at your own risk. Kahane Law Office, Merrick Law, Heather Malarick Professional Corporation, Evan Clarke Professional Corporation, Evan Clarke, Heather Malarick, and any guests will not be responsible nor liable in any way for any content, including but not limited to any errors or omissions in the content, or for any loss or damage of any kind incurred as a result of any content communicated in this video, whether by Evan Clarke, Heather Malarick, or by a third party. Kim McDonald is a financial advisor with Raymond James Limited. Information provided is not a solicitation, and although obtained from sources considered reliable, is not guaranteed. The view and opinions contained in this media are those of Kim McDonald, not Raymond James Limited. Securities-related products and services are offered through Raymond James Limited, member Canadian Investor Protection Fund. Insurance products and services are offered through Raymond James Financial Planning Limited, which is not a member Canadian Investor Protection Fund. Raymond James advisors are not tax advisors, and we recommend that clients seek independent advice from a professional advisor on tax-related matters.
Stole my heart from my lips. That was it.